Hi, my name is Gilbert Ambler, and I am a criminal defense and firearms attorney practicing in both Pennsylvania and Virginia. Today, I want to speak with you about the concept of imminence. Imminence is a term that is commonly thrown around in self-defense cases, seminars, and publications, but do you really know what the term means in the legal context? Depending on the state, imminence is often codified or required by common law for a successful justification defense and is typically included in jury instructions through the term immediately necessary. This means that among other requirements, a threat must be immediately necessary before a self-defense response would be justified. When explaining imminence requirements, I typically tell people that a threat must be close in time, space, and certainty before they would be justified in responding to it, or responding with force at least. What does this mean? Close in time means that a threat must not be a future threat. Someone saying they're going to kill you next week, while obviously a concern, alone could not be used to support a defensive response with force. Close in space refers to a law enforcement concept known as the 21-foot rule, although personally I disagree with the terminology. I think it would be more appropriate to call this concept the 21-foot guideline instead of a 21-foot rule. This idea stems from the work of a police officer named Dennis Toller, and the concept revolves around the idea that it takes the average law enforcement officer 1.5 seconds to draw and accurately discharge a firearm, while at the same time an average person is able to run 21 feet in 1.5 seconds. When we put these facts together, we get the concept that once someone has motive, means, and opportunity to cause you harm, and they get within 21 feet of you, they become an imminent threat because they can probably reach you before you can do something about it. Finally, the threat must be close in certainty to actually occurring. It cannot be an attenuated or unreasonable fear. The threat must be close to actually being carried out. In Virginia, an overt act or a substantial step towards the attacker actually carrying out the attack has to occur before a response with deadly force would be justified. To understand what the imminence requirement looks like from the perspective of the law, I would tell you that the threat becomes imminent at the point where you cannot wait any longer before you respond. If you imagine someone who starts by verbally threatening to shoot you, but then starts to act on their threat, the threat likely becomes imminent when they actually go for their gun, because at that point, you probably cannot wait any longer. For more questions on imminence and the justified use of deadly force, I encourage you to attend a U.S. Law Shield seminar, which I regularly speak at. These seminars can be found by visiting gunlawseminar.com. Alternatively, you can contact Ambler Law Offices at 540-550-4236. As required by law, I must mention that this video is attorney advertising, and while I am a lawyer, I am not your lawyer, and the contents of this video is not legal advice. If you would like me to be your lawyer, call Ambler Law Offices at 540-550-4236 for a free consultation.